Good morning, everyone. How are you? I made some instant coffee for myself this morning, and it's rank. There's completely add like a half a creamer in there. Good morning, everyone. How are you? Bling, good morning. First one in. Wow. Hi, Susan B. How are you? Tater. I came on a half an hour early so I could say hi to everyone, and then I was excited, so I started earlier than I'm supposed to. But I was excited because I got to turn my phone on. Do not disturb. DND. Hi, Shelly. You'll check back in when we're going live. Thank you. Hey, Tater. Tater, when I first logged on to my computer this morning, I saw she's weak, and I'm like, who's weak? You're right. I think the judge is weak. None of this would happen in our county, in our courtroom. If the judge doesn't bring the hammer down on this defense team, she needs to be removed. Well, she's not going to be removed. And I think it's a 50-50 shot on whether she, instead of bringing the, gonna start laughing. She'll just order another voir dire. Like, that's what she does. Instead of like saying no to the obvious, she's like, we need a voir dire. What are you doing? You don't need a voir dire. Oh, good morning, Barb. So ridiculous. Hi, creative. Shelly, one thing for certain is the spotlight is on her today. Everyone is watching. Everyone's been watching. That poor woman's been more ridiculed than some YouTube creators we know. I mean, she's been ridiculed. Like, if I were her, I'd get that hair out of my face. Just show up like you're meant to work today. Good night. So upset by stuff like this. Like, you can't work when your hair's like, my dad would be like, get that hair out of your face. Hair's all in her face. She's looking down. It's like she'd rather be anywhere else but there. So crazy. Hi, Leslie. How are you? Sorry, you have to work today. Well, I'm going to mute my microphone for a good bit of this and watch while you all chat because I have to work. Not too much, but I do have to work. Hi, T. Jebby. Hi, how are you? Hi, Becky. I have friends in Ireland right now. Looks like they're having such a great time. I got to sit back. I know Murder's probably going to be on with Roberta today, but this whole camera, I gotta work on it because it's like make my eyebrows look fabulous today, and you can't even tell. It looks like they're splotchy and just let the laughter out. I do. I was like, hi, Kim. I have the serious giggles today. Well, I have a serious giggles most days, but so I got to tell you, my daughter, Ollie Mae, just got out of surgery. She had, she's deaf in one ear, and she's been wearing, I mean, she's not that old. I don't know the cause of it. I just know she's deaf in one ear. So she was wearing hearing aids, like high-end hearing aids, military paid for it for a long time. And now she has, it's not a cochlear, but it's something like that they just put on her head. And she has this gorgeous, to have her hair. This gorgeous auburn, natural, beautiful hair. And they're having to shave part of it, I guess. They were, to put it on their head. So it goes into her skull and then it'll be there. But she's had problems even with the hearing aids because she gets all this fluid, this clear fluid out of her ear. She doesn't have a hammer in her ear anymore. All of that's gone. And they tried to put an artificial hammer in, and that didn't work. It didn't take. So now she's having to do this. So she's in there. Her hair needs serious help. We're talking about Judge Bev Cannone. That's how I say it. I don't know if that's how you say it. It's Cannone or Cannone, but I wouldn't give to give that woman a ponytail. Judge Everett should be the judge for every case that we watch. I mean, it's really been a challenge. Melody Ferris, that judge was like happy to be on TV. Like he was getting headshots in between bench conversations just because he thought he was going to be made for TV. I know. I think that's just how she wears her hair. I mean, I looked her up. She was a public defender. Her hair was the same way. And we always tell people in real estate, people don't change their taste. They don't really. I'm Patty Wilson, in case you didn't know. You're just tuning in. I'm Patty Wilson, and this is Patty's Playhouse. And today we're going to watch how do they describe it on Court TV? Massachusetts, the Commonwealth, versus Karen Reed murder retrial motions hearing. And what happened last week was a debacle. Not really. It was very entertaining. Hank Brennan, who's the special prosecutor, he has formerly been a federal prosecutor. He's been a defense attorney. He brought to Judge Beverly attention that it appears as if the defense was having conversations with a witness they were not supposed to have conversations with. And the witness was ARCA. And ARCA does accident reconstruction. And they've been bought by another company. It used to be ARCA Inc. And now it's ARCA LLC. And they have offices really all over the country. The one in Florida is in Hollywood, Florida, down by Miami. And this guy, I mean, just a guy from outside of Philadelphia started it, and it became very prolific. And they get federal contracts, they get government contracts to do accident reconstruction. And apparently the feds had brought them in to do this reconstruction, but the defense and the prosecution were not to speak to them. They were persona non grata, like, don't talk to us. Nah. And feds were paying them, and that was their contract. Well, that's not everybody that was paying them. So apparently there was an invoice for about $23,000 to $24,000 paid for by the defense. Alan Jackson's the lead defense attorney. He was the lead defense the first trial. So it's come out during discovery that there was a payment to ARCA, ARCCA, and this approximately $1,000, because, you know, the defense side of the world will like literally parse every comma, period, adverb that you say in a sentence. So it's an approximate number, because I haven't read the invoice, of $23,000. And they're saying now it's for travel. Well, these people are coming from Philadelphia to Boston. I just looked it up yesterday or 2 days ago. Sunday? How much does it cost for Alan Jackson, who's based out of Los Angeles, to fly to Boston on a minute's notice? $1,000. So $1,000 round trip. You can go from Boston to LA. So that means there's a lot of flights. It's a repetitive flight, which is why it's so inexpensive. I guarantee you Philly to Boston is about the same. So even if they took 4 guys, that's $4,000. Hotel overnight, like it's really getting hard, which they didn't take 4. I think they had a team of 2 to get up there to Boston and back. It's not $24,000. So now they're calling it travel. No. I'm going to Rome. in November. The whole thing isn't $24,000. Like, it's not $24,000. It's not happening. So we'll see what happens. Bev was very pissed. She went back into her chambers. I believe, this is just conjecture, she went back into her chambers and made some phone calls. Came back out. She was even more pissed, shaking pissed. So something happened back there. And she gave a command-only audience today that they had to be there. She asked about the 25th this morning at 11 a.m. And of course, Alan Jackson stood up and said, I have a problem. He always does. And then he was like, can we do the 26th at 9 o'clock? And that's when I went into panic mode because Donna Adelson has a trial tomorrow, a hearing at 9 a.m. I've got places to be. So they went around the defense table and talked to Karen. Like, Karen has a say-so. I'm like, girl, you're on bond. You have no say-so. Like, you just need to show up at the hearing. And then they said, okay, judge, we'll be there. Like, what did they have to do? So, I mean, there's rumors all over the Twitter X, that Alan was seen crying at the Omni. I don't believe that. I do believe he looked nervous because he dropped his elbow on the table. Like, he had his elbow up like this and then dropped it on the table like when he was writing, and it looked like it hurt. I think he had other things on his mind. He really didn't look up. And then when he left the courtroom and they were all in their gaggle, blah, we're so important, that he said, what did Judge Bev mean? I have no idea. I have no idea what she meant. Of course, just keep walking, dude. You don't have to answer everybody. You don't have to answer. Just keep the walking. So anyway, that's the update on what's going to happen today. My favorite part's going to be Karen walking into the courtroom because she always walks like she got off of two horses' dongs. So she's like, that'll be my favorite part. Will she walk in like she's walking off like she just got off of a horse's dong, or is she going to just like walk in like a normal person? Hi, Susan Hicks. How are you? We got so much rain yesterday, but it is beautiful today, but I'm still freezing. I gotta figure that out. But I'm freezing in here. Did anyone watch Carl on YouTube on Sunday? I heard about it. But I didn't watch it. I might watch it today while I'm working. Thank you, Susan B. That's very nice for you to say. Hi, Chris. How are you? We are... I wish I was the sleuth of the trial. I wish all states had Florida's regulations as trial dockets. So much harder to find in other states. Your family is from Clonmel in County Tipperary. Oh, lucky you. Do you go? I mean, your name is Ireland. Do you go to Ireland? I had a client once back in PA. Her son was on a ventilator. So I would do home care. I would go in the home, take care of these children on ventilators. And her last name was Ireland. And I was just like, oh, your name's Ireland. I can watch this because buyers have asked for a 2-week extension and put down more deposit. Well, that's all you can ask for. That's all you can ask for. Look at the link Tulip posted today. Hey, Debbie Martin. On the DMM sub, it addresses something on that phone call you listened to that even I missed. Oh, okay. You're talking about the Dan Markel murder subreddit. I will go back and look at it. Thank you. It's nice to see you. I haven't seen you in a while. Hope you're doing okay. Hey, Stokes. Prayers for your daughter. Thank you. I'll tell her. I know. It breaks my heart because, like, my kid is deaf. It's the oddest thing. She had a long time ago. I mean, she was little, like booster seat little in the back of the car. And we were driving home from Bucks County seeing First ex-husband's mother. And she just started screaming out in pain. And she had had an earache, like she had an infection. The infection, it was green when they took it out. They took this massive plug out of her ear. Her eardrum had ruptured. I didn't even know she had an earache. And it was before I was probably in nursing school at the time. But they took these long freaking tweezers and pulled this massive plug out of her ear. And then this green stuff, a pseudomonas is what it was, came out of her ear. And she had problems with it growing up, like swimmer's ear or whatever, but never that again. And then she goes to the military and they talk about the burn piles and she came back deaf. Saddest thing. But she's super positive about it. For me, it's like listening to her like she's going to get a facial. Like, that's how she sounds. She's like, she just started a new job yesterday with the federal government, and she's in on the defense side. She's on that side. And then she said today she was having her surgery, but she honestly sounds like she's going to get her eyebrows tweezed. I mean, it's like it's no big deal. And meanwhile, I'm like, just heartbreaking. Hey, Granny. But she really has the greatest attitude about it. Prayers for Ollie Mae. I'm going to tell her. I'm going to take a little screenshot of that with people saying that. Hold on. Because it's so nice. I like the judge for Corey Richins too. I just don't know why it's so hard to be a judge. I'm like, you're a referee. You got to pick a side, dude. Like, pick a decision, not pick a side, defense or prosecution, but pick a statement. Like, pick. Like, this is the way it is. That's why you got the little hammer. Tater says, I can't watch Carl because Carl Steinbeck is his name, and he has a YouTube channel. It's quite, I think he has like 24,000 on there. He gets quite a few views, but I don't know if he's watched the Karen Reed trial since, gone in and looked at the docket. So I'm not going to judge him. I haven't talked to him about it yet. And I haven't watched him since Christmas. So I can't really judge what he says until I listen to it. Hey, Michelle. Hold on one second. Someone's here. I'll be right back. There is no doorbell.
Oh, that's it. Protected by Ring doorbell.
Yeah,
I was like,
I'm on
where's
a
the
YouTube. I'm on a YouTube. Yeah. Do you want to come in?
You gotta leave?
Yeah.
Yeah.
Okay. I'll show you where it is. Can you shut the door? We don't have a doorbell.
Oh, I said it. This thing said protected by Ring. I came here Friday.
We have a Ring camera. Yeah, but we're not always in here. So, the ladder's there. The leak's coming up from up there.
Is it around that?
I haven't been up there, but you'll see all the wet wood. Thanks. Sorry, we have a roof leak, so we have a gentleman who's in here. Gibby said that there are people who hate. Gibby and he said there are people who hate Karen Reed's guts in his tone when he said it was vicious. Well, I think that, we don't know Karen Reed, but I think the thing is that her people who work on her behalf have really tried to destroy lives of anyone who disagrees with her. So you're going to have a reason to respond. Hi, Coercive. How are you? I can't believe it. I can't believe Brianna Price. And if you watch the Adelson trial, it's Charles Adelson's baby mama is Bree Price, and she got a DUI. And she's had a couple fraud charges, theft, identity theft. And she has a warrant out that she should be arrested, but I don't know that she's been introduced to the court. Her bond was revoked. She's got an arrest warrant. Who knows? Original fraud case was from 2022 and new charge, fair stuff the same way. Oh, Wayfair makes you wonder. I mean, we don't know who did it, but somebody was in Maryland. I don't. Over 30 of us were muted that night. Oh, that's the original night that he went off on Karen. She's what they call an unsympathetic defendant. I find her off-putting, but don't think she's guilty. Oh, she's definitely an unsympathetic defendant. I mean, I've never seen a defendant behave the way she does in a courtroom, other than, you know, some of the psycho ones that like lash out against the judge and jump over the judge's bench. Perception is reality most of the time, says Chris. It's true. I mean, it's true. Let's see. There were trolls in there, like every channel. Every channel has trolls. He's been good about, I mean, he's decisive. Carl Steinbeck's quite decisive when it comes to people in his chat. It is hard to keep up with trials, especially since it's not my full-time job, right? It's not something I always have court in the back of my mind, but time is at 10:49. There's no remorse for losing John. She despised him that night.
Yeah.
Yes.
I'll be back.
Thank you.
I gotta go get some material to go to fix this.
Okay.
Yes, ma'am.
How long will you be?
I don't know. I gotta talk with my boss and see if we got a skylight because something fell and hit your skylight. And
It's
cracked
probably a tree from the storm. It happened
it. I remember.
after the tornado thingy.
Yeah.
We also have leak. Can you go look in the kitchen area back here?
Is it on the end wall of the building?
Yeah.
Because I can see where it was leaking.
Yeah. It's the drywall starting to get damaged.
Yeah, that's right above where I was just looking at.
Okay, good. I wanted to make sure.
Yeah, it's gonna need some patches. I gotta put a few patches on the end of the roof, and then I gotta change that skylight out. I just gotta make sure we got the skylight.
Okay, cool. Thank you.
Yes, ma'am.
Do you want my phone number
That
just
would
in
be
case?
helpful. Yeah, just in case it ain't right immediately. I'm gonna go up
Here you
there.
go.
I'm gonna go up there today and fix everything that I can fix. But if I don't got the skylight, I might have to
But
order
I have
it.
to run to the mailbox, to the post office. So just text
Well, I
me.
shouldn't need to get. I shouldn't need to get in to be able to do it.
You'll be back on the
I can
on
get.
top.
Yeah, I can get.
Fair play.
Yeah, you'll know. You'll see the brand new skylight, but I'll call you and let you know everything that's going to
Thanks,
happen.
love. I appreciate it.
Thank you.
Just slam that for me.
I got you.
Thanks.
Yep.
Well, that's good news. It's just one area that's leaking because it was leaking. So we in Tallahassee, May 10th, we had tornadoes, and then we've had hurricanes, Hurricane Helene, and I think Ian too, right? Came here. So there's skylights in the roof of this metal building that I'm in, and there's just ceiling leaks everywhere. So he says it's all coming from a skylight. So hopefully they'll fix that today. Well, a lot of people, not to make fun, but would burn down their house for a rat. I've actually seen it happen. It's like, they'll burn. People will. They'll burn down their house for a turkey. Like, I'm going to put the propane right next to my house. I got it. I fixed it. Hi, Wesley. How are you? You need a roof? So does this building. I'm sure they're self-insured. This guy, his last name's Farrell, Ferrell, and he owns, I think, 80% of the warehouse properties in town. Like, he owns this plaza area that I'm sitting in. And if you live in Tallahassee, we're next to the Lumber Liquidators. It's kind of catty corner to the Dairy Queen, which I never go to, by the way, because if I went, I would go all the time. And he owns this. He owns across the street. He owns down the road. Like, he's about 92. And from what I know about him, they're all paid for. Like, it's all self-insured. So whatever happens on this building, they just pay out of pocket. It's loaded. I've never met him. I've just heard a lot about him. Tater, when I bought my house 6 years ago, we put a tin roof on it. Nothing better than a tin roof. Good for you. I can't imagine what that would cost now. Oh, I was super excited today. These things make me excited. So Russia made a deal with Trump, the United States, about importing aluminum. So we have to import our aluminum for whatever reason. I don't know. I don't know about aluminum. I don't know how it works. But I know aluminum right now is extremely expensive. So they made a deal to import aluminum, praise the Lord, because everything has aluminum in it, right? Fencing, gutters. My daughter had an aluminum fence put in around her yard for her dogs. And she had to do that because where she lives it's called a borough, in Pennsylvania, required it. You couldn't put a privacy fence in. She's not in a HOA. It's just the restrictions from the borough. You know, there's like cities, towns, villages, boroughs is what it is. And $9,000. $9,000 for a fence. So that's what, but they work too much to be able to let their dogs run. They've been taking the dogs out for the last 3 years, and they're not small dogs. But aluminum is so expensive. So here in town, we had the snow and ice, right? Which was a little ridiculous. And I'm just making sure it wasn't on. And I can attest, hundreds of cages over a swimming pool. Some people call them a bird cage. Some people call them just a screened-in pool area. Destroyed because of the snow and ice. They're not meant to carry weight. And I can't even imagine what that replacement is. Many insurance companies won't do it. So you're just out of pocket. And so if you have a screened area over your pool, it doesn't require a fence. Most have them. But if you don't have a fence and you have the screen-in pool, you got to put up a fence. It's so expensive. So I'm very happy today about aluminum. Makes me happy. You have a metal roof, but don't know what style. It's a beach house, Bahama style. Nice for you, Jebby. You'll take anything but spiders. The tariffs on steel with Canada will affect your son who works at a steel factory in Hamilton. Well, the town that I'm from, where Ollie Mae lives, is actually Steelton, Steelton. Steelton. They don't say Steelton, it's Steelton. And it was a steel town. There's a steel mill there. But back in the 70s, early 80s, it got shut down because they started importing steel instead of buying American-made steel. So I get it. Aluminum is awesome. Snakes keep out my husband, and I'm terrified of spiders. I handle all snakes, and he takes care of the spiders. You do know that spiders eat other bugs, right? It's 50 degrees there today. Well, then she should be preppily dressed. Preppy. Wesley in Nashville, it is sunny and warm for the first time in weeks. Last night, the rain sounded like machine gun fire. I thought our pool was going to overflow. That's about the... I thought about putting a metal roof on my house, but then the metal, it was like $22,000 for 1,000 square foot. No. It's just not worth it. We don't kill spiders or snakes, just relocate them. So when I had my trees trimmed before the tornadoes, which I guess I'm due to try and get some trees trimmed now, because I try to bring them out once a year. They took these massive limbs off of my live oaks, and snakes were in the limbs, and I just ran. Like, I don't even want to deal with it. The guys thought it was funny. No, I'm not being funny. I'm petrified of a snake. You have an eastern king snake under my front porch at Lake Arrowhead. No poisonous snakes there. Will that snake go in your house? Wesley, does that snake go in your house? Jesus, no. No. The Latin name is Lamprobeltis, Getula. No. It's a harmless colubrid species endemic to the United States. The eastern king snake feeds on other snakes, lizards, frogs, rodents. I bet it does. Children. Just kidding. Doesn't feed on children. We have a few rat snakes here that keep the field mice under control. We have a few water moccasins too, and I don't want to know the difference. So, and I'm 3 houses down from a large pond, which at night you can hear all the frogs mating. It is so loud. No. I'm sure there's gator. No. He lives under the porch. Occasionally crawls under the rocking chair, but I just put him back under the porch. Do you have like a hook? Or do you just hold him and move him? I have a hook like that. My dad made it for me in case I saw a snake. It's a golf club that he took the head off and he put a hook on it. Just in case. When I was a kid, we had gardener snakes in our backyard. I had to stop the lawnmower all the time. After your mom died, the real estate lady called me and said, a snake just went into your house. I love the little geckos down there. I do. I don't mind a gecko getting in my house at all. We have white ones. White geckos. Because I know they eat all the bugs. It doesn't bother me. But I have pest control. But I rarely see any, what do they call them? It's a roach, right? But they call them here palmettos. They have to be special about it, but it's still a roach. And I don't see any. Crickets and frogs is all you hear out here at the woods at night. Well, it's all you hear, and I'm not out in the woods. I'm telling you, at night is so loud. Golly. I wish people would go gig the frogs. Like, go get your dinner out there. Snakes creep you out too? I pick him up. He's 5 feet long. You have guns and snake wrappers everywhere. What's a snake wrapper? I love how people think I know what you're talking about, and I don't. A snake wrapper is a collection of reusable wrappers that allow you to quickly, snake make. It's a grabber. You use a hook. Okay, good. Flying cockroaches are palmetto bugs. You haven't lived. Oh. Just a second. He locked himself out.
can I need to pull a measurement over to your kitchen off this wall real quick.
Yeah.
Okay.
Just know I'm on YouTube.
We do, I believe, got a skylight.
Oh, praise the
I
Lord.
should be able to fix it all.
Thank you. You're watching from Scotland. Well, that would surprise me. It would surprise me if you were watching from somewhere else. We have coyotes. I think they're mainly on the northeast side. I haven't seen one on our side. We have bears on our side of town. Susan has the chicken coops. Do you see, Susan, do you see coyote on your side? I would think you do. They're massive here. They're so tall. Ooh. We have a lot of fox, too. Hummingbird coming in. Okay, it's 11:03, people. Oh, there we go.
Suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing: transcripts, documents, probative issues. And if, with your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed you, or bring it up?
A court officer will take it for you.
Okay.
I appreciate that, Mr. Lessie.
You're welcome.
Thank you.
There's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay. You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
You are muted.
May the ass kissing commence.
Mr. McDermott? Mr. McDermott? Yeah, first of all, good morning. Good morning.
Oh, she needs a break to read the document.
Thank you.
Well, what just happened is she went over to why she suspended the hearing last week, which was a motion hearing. So she explained why she ended the motions hearing. She's giving the defense an option to speak instead of Jackson speaking, because he is there as the guest of the Commonwealth. He does not have a Massachusetts bar license. Alessi speaking, and smoke will blow, as someone wrote. He had a full document, so she's asking or telling them she wants 5 minutes to just briefly review the pamphlet he brought her. Not a pamphlet, but whatever. Even his tone is so conciliatory. It's like, we are really screwing up. Alan is not licensed to practice there, and he could pull that. They could pull that ticket. They're calling it a ticket for him to even be in the room. Well, I mean, she wants to read it before he starts talking. I don't blame her. That's the smart thing to do. If he hands her a 100-page document, she should be allowed to look through it. This just shows you how small that courtroom is. Look at that. This is a very small courtroom. So if you don't know, we talked about it on Sunday. Nick Rocco, who is part of Karen Reed's PR team. Nick Rocco was auctioning off a courtroom seat in the trial. Now, I tried to call the clerk of court, but no one took my call. They have to know. Nick Rocco removed the post, but I believe money's already been transferred to Karen Reed. I don't like any attorney who's pro bono for things like this. Like, to me, you're just a hanger-on. I think that was stated really well. So I apologize for the people walking back and forth, but our group is sleeping here in the warehouse. So.
I know. Oh, I fixed it. Okay. Sorry.
They're right up there. They're right up there.
You are unmuted.
No, the other side too.
They don't know, but we were unmuted the whole thing. I'm muting my own mic now.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, You can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor. And because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you were addressing this in chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them,
Sure.
but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your
I
number.
will tell you exact
8.
pages that I'm going to refer to. And Your Honor, get to this is tab 8
Right.
of the notebook.
Mm-hmm.
And specific pages that I'm going to reference start on page 53.
Okay,
And those are 9 pages that proceed all the way to really the substance ends on page 62.
okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to
You
suspend my
can,
brief or keep going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right. Go right ahead, Mr. Lessie.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts. But I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report, that the vehicle and the substance is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact, but either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know, but I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was the hope.
Was the federal protective order that was referenced by Ms. Giannetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, no, I wanted to say, I'm going to answer it directly. What Mr. Yannetti articulated is the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCA experts. Okay, that was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand. But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email. And my understanding is Mr. Yannetti is not knowledgeable about these communications. So the email reads, "Hi, Alan, subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly in code at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA is willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only for the non-evidentiary transcripts I reviewed was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get that.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th. And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire, and that the ARCA witnesses were going to have to come up from Pennsylvania, and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCA, so I've read that report.
28.
I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court, and it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question
That's
was-
exactly what I said.
Pardon me?
That's exactly what I said.
Yes, and I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes two people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. And I know the immediate response might be there. It might be at this point, wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is not fighting with bringing them in for a voir dire. That's Mr. Yannetti says that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get you how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3. And it's the June 18, 2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anyone.
Don't you think he has to make a
any
point?
question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right? I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. we got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lab. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages, not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask. And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face. And one of it is you can always tell what goes along with the email. So this is attachment Wolf Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay, so he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab, and of course, it has the D&T of Dr. Wolf, his experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the rule 14. And we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing, because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this And when Dr. Wolf is on the stand, because that's the really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think, perfectly tailored to the situation to basically say, I don't, as the court, understand. These folks haven't gotten what the court found was their proper discovery. We're saying we don't have, you know, the information to turn over in terms of it. We got the report, and all we had is emails in March, right? That are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up? Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, you know, a great deal of my work is in the field of lighting and visibility. So there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No, that's correct. Mr. Yannetti? No, fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question, when did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer, correct. Question, and that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say, this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. To the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct, question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having, but he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will
You
not.
can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And I
If
said
you
it-
know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I think
Okay.
the only way to fairly.
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding. Yes. And you were equally available to both sides in terms of them reaching out. Correct. Yes. And I called you ultimately after receiving your report and asked if you join us and testify. Correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf. And I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they had. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle? So it's important to know, in terms of, you know, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, you know, the findings of ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial.
Right.
I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective. These are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th. And I think I can get you the exact dates here. Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer?
I would like that.
Sure. I'm going to attempt to get an exact. If I can't, I think I can get a good approximation. Your Honor, I understand a check was sent to ARCA on July 25th.
Thank you.
You're welcome. So there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, what the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's very important question. But it's an important fact point as well that call was made. So in terms of the next tab, which I've been alluding to during
Okay, so this is the one I said I needed to take a recess to read
I was just going
that.
to say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
All rise.
You are muted.
So I just put in the chat that Benjamin Elliott, who said he was sleepwalking when he unalived his sister with a knife numerous times, only got 15 years. Unbelievable. Unbelievable. Whew. Oh, Neely, that's funny. I like that movie, Chicago. I've been watching hearings to see if the rake murder husband gets a new trial. The hair in your tires is changed. No, you didn't miss anything. He's still on the same paragraph. He is still on the same paragraph. I thought Catherine Magbanua said nothing in 2 hours. This guy tops her, like literally nothing. You're in Iowa, you think Todd Mullins is guilty. So do I. I mean, he sits there looking guilty. He's not even sitting there looking like he's it's a moron. Oh my God. Oh, the University of Virginia is oh, what a beautiful place too. God, that place is so beautiful. Under shelter in place, an armed and dangerous. Let me see what it says. Oh yeah, there's a guy out there. This is what he looks like. University of Virginia Department said students, faculty, and staff. Police said they're looking for a suspect. All students and staff should shelter in place. The suspect, 6'1", black male, wearing a gray hoodie. Naheem Hill said he was last seen on Alderman Road. He's known criminal history. Well, then let him out on the street. I mean, that just makes all the damn sense in the world, right? And gang affiliation. Send them all to Gitmo. Screw this shit. I'm so sick of it. Just send anyone in a gang, send them to Gitmo. They'll ungang themselves real quick. Dude, I remember the first time I drove by that university, coming home from Pennsylvania, I was like, this is God's country. Oh my God, it's so beautiful. This is why I stay home too. My college, Tallahassee State College, had a shooting on campus. Yeah, last week it was shelter in place. I mean, just send them all to Gitmo. This is ridiculous. You want to see anyone ungang yourself? Go to Gitmo. Yup. This Alessi thing, I'm sorry I keep laughing. Like, how big is your binder, dude? It's like your binder must be as big as Wendy Adelson's divorce binder. Oh, she's been in a classroom for an hour. I'm so sorry. Wesley says that's why he has concealed carry. I was an expert marksman in the Army. Well, if you recall, I went in the Air Force. Okay. We're not taught to shoot. Like, you get one day at the shooting range in the Air Force. I know, I'm afraid I'd shoot my foot. I know realtors that carry on in their ankle. They have an ankle strap. Yeah. I would be like Sigfredo Garcia in the Dan Markel. That would be Patty. I would shoot the floorboard. I wonder if any other docs are on for that Adelson trial tomorrow. me look it up. I'd be an Abbott and Costello shooter. Donna's docket is massive. It is just like you got to scroll your whole way down the computer. Nothing. No, just the normal. Tomorrow morning. What is it? Tomorrow. Oh, there's a case management conference set for today. Wait, hold on. 9 o'clock tomorrow morning. There's a motion hearing. Let me see what this says. There might be one today, but I'm not going down. Oh, March 25th. Not today. Okay, March 25th. In Courtroom Z, which means Zoom. All interested parties are hereby notified. Case management conference. So that's what that. March 25th at 2:30, but I'll be there. Notice of filing the transcript, notice of appearance. Yeah, nothing new. I'll check before I leave today. You can't wait for that hearing tomorrow? 9 a.m. means I got to get up at 6. I don't know how attorneys do it. Like they got to be there. They must have to get up at 5 for some of these cases. I can stay up till 5 before I can get up at 5. Like it is dastardly for me. Today, I had like 4 alarms set. So if you're just tuning in, I'm Patty Wilson and this is Patty's Playhouse and we're watching a guy just ramble. His name's Robert Alessi. He's an attorney out of New York. His firm is DLA Piper. He's an energy and environmental attorney who loves the sound of his own voice, but he is shaking a little bit. Like his hands are shaking. So I don't know if he has like essential tremors or something. I don't know. But he's that curly haired guy with a hook nose. And he has just been going on and on and on and on. And if there's any substance to it, I haven't found it. According to someone on Twitter, or X, I copied his comment. He said he feels like Alessi, Alessi, is trying to insulate Yannetti. Yannetti is the Massachusetts attorney who is the lead, the technical lead in this case. Alessi, I don't know if he's licensed in Massachusetts, but Alan Jackson is not, and he is there as a guest to the Commonwealth of Massachusetts. You were up at 3 o'clock this morning watching the pool water. Yeah, that would bother me too. Wesley's on the East Coast time. Cool beans. Redefense is trial through loophole and manipulation. I know. Yeah, Turtle Child is like, he said, Bev's not in a good mood. She's heavy breathing. What's that got to do with it? I hate early. I've never liked early mornings from the time I was a tyke. I had afternoon kindergarten, and that was probably the best time of my life because I didn't have to go to school till 1. Like, I just don't do well with it. I worked night shift as a nurse for all my years, and if I'd worked day shift, I don't like administration. Yeah, to do like one time I worked They wanted me to do like 7P to 11A. That last 4 hours, I thought I was gonna have to be put into a coma. The lack of sleep and the overdose of caffeine, I was like, I don't even know how I drove home. Yeah. But there are people that do it. They'll do 7P, or 11, or they would do, I know what it was, 11P to 11A. Yeah, I'm out. It's never happening. But I did do 7P to 11. Oh, brutal. You're on the transplant team at Yale. I did more all-nighters than I can count. Oh, I love the all-night shift because it's so quiet. It's quiet. Unless someone's crashing, then it's not quiet. But most nights are quiet. 11P to 11A is ridiculous. But sometimes you'd have to stay. I would just have the shakes. I can remember driving home, and this is at our local hospital here, driving home and having the AC on no matter what time of day it was, and bringing an ice pack so I'd put ice on my wrist so I wouldn't fall asleep. Oh, that was my life. Don't miss it. Oh, no, that's brutal. No. That's 3 meals. You got to pass 3 meals. You have all those meds to pass. You have admin. No. Oh, no. Chances are you're going to a meeting that means nothing. No. You were there all day and all night. The longest was 36 straight. No, I didn't have to do that. I was just a floor nurse. Whew. There's nothing worse. There's nothing more boring than a nursing team meeting. You're literally not accomplishing anything. You can make no rules, no policy changes. You're just there because someone requires it. It's literally ridiculous. Admin never come to the ER. I couldn't work in the ER. No, I'd probably catch a charge. These moms coming in there. Nope, screaming at staff. I would walk through. I used to take blood, do lab draws. And I would walk through, and these moms are screaming at nurses because they have to give their kid a shot. Or the moms are screaming because the moms know that they abused the kid, and then you're taking your kid. No, I have no time for it. None. Nope. I don't like this. How do I say? Lack of intervention on bad parents. I don't like it. It's hard for me, so I wouldn't do it. I did blood draws on the pediatric floor at TMH one day. One day. I had to take this kid's blood. I mean, you have to. First of all, it's how they find out they have an infection or platelets. Like, it's important for these blood draws. This mom lost her shit on me. I was like, I'm out. Like, you are so smart. You do it. I was like, I'm out of here. Never going back on the peds floor again. Nope. I have nightmares about that lady, honestly. I mean, and why I know that the parents are like, if your kid is like really sick and you're a loving parent, not an abusive one, most of those parents, I'd say 98%, are supportive of the nurse getting the blood draw and just normal. Like, they're normal. They're anxious or apprehensive, but they're normal. That's normal. The woman or women and men, I'm sure there was a guy, I just didn't experience it, that literally go over the top dramatic because you put a needle in your kid's arm. They're the ones who abuse their kids, and they're afraid it's going to get caught. And that's why I was like, no, I have no time for you. You're an addict, and I want nothing to do with you ever. Like, I I just can't handle it. So I don't. Like people say, Patty, would you ever go back to work as a nurse? If the housing market crashes, yes, I will have to. But it won't be on the floor of a pediatric. They just don't want me to do. The parents are the worst part of the job. But I am serious. Like if you love the kid, then you want what's best for the kid. I don't care the age. A friend of mine right now had a baby, weeks ago now. He's still in NICU. I mean, she had him. He was a peanut. Like he was tiny. I mean, just angel hands touch that baby. Like that is the way this works. But if you are a parent who's trying to cover up some shit, you will be super dramatic and blame anyone who comes in the room to protect yourself. So it's just the way it is. Hey, Lovely's been struggling to get a signal. Do you have the Starlink, Kaza? Whew. Oh, I think so too. And idle hands. I think it's a lot of it's idle hands. People don't have enough to do. We were talking about that before Mass this morning. And my friend, and they actually sponsor the radio show. My friend was like, I think what's wrong, Patty, is people have too much time on their hands. I'm like, I guarantee what's wrong is too much time on their hands. People just sit around and ponder, what are other people saying about me? What are other people doing about me? Blah, 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 blah. You'd want to work the psych ward. I'm not allowed to do that either. I did it at the state hospital in Harrisburg, Pennsylvania, was the first mental hospital. I think Dix, I forget her name, but it was Dix, D-I-X, opened that hospital. It's now closed. And there was a fire there recently. It's beautiful. Like inside is like old hospital. It's really pretty. And there was a lady, I only did a week. It was a week of rotation. And a lady was walking around literally with a tinfoil hat. And she was like, they're listening in. I shouldn't have opened my mouth. And I was like, it's because you have a tinfoil hat. Like you're bringing the radio waves to your head. Of course they're listening in. And she was like, you're the only person who's ever listened to me. And I was like, I mean, they are. Take the tinfoil hat off and they won't be able to listen to you anymore. And so she took the hat off and she walked away. She didn't come back. But I was reprimanded, as I probably should have been, because I was a nursing student and you were supposed to redirect. Why? She's not coming out of here. Like, why can't we just like affirm and move on? Like, yeah. They didn't have an answer for that. They just said, don't do it again. And I said, okay. I was like, there's a reason they can hear you. So funny. Patty, I seriously have never understood why the constant redirecting of someone who is schizophrenic, like out of it schizophrenic, not like a working schizophrenic, but like truly seeing and hearing things. Why? They're not coming out of that. Did you think me saying like, oh, honey, I can't say that. You can't say honey anymore, but I probably said it in 1995. That's not true. Go on, go watch TV. Stupid. They closed all the state hospitals. I know. I wish they'd open them back up. You'll get here in Florida, it's called a Baker Act. So if you threaten to harm yourself, they Baker Act you for like, it's supposed to be a 72-hour hold. No. It's like 12. Giovanni, good morning or afternoon. So my understanding is that ARCA sent an invoice to the defense. The defense then reached out to the Department of Justice about paying ARCA. Got the go-ahead and paid it, then paid it on July 25th. Well, if you got that, then that's more than I got out of it. I honestly cannot I didn't hear any of that, but this is something where I honestly would have to read the transcript. I have no idea what he said. You can't say honey, but sugar is a good one. You could say sugar here. I got the Jackson F. Also, Brennan lied in open court about that bill not being dated. I don't think he said the bill wasn't dated. I think he said the email wasn't dated, but I could be wrong about that too, Giovanni. It took him an hour to say it. Longer than that. But we do know so far tomorrow morning at 9 a.m. starts Don Adelson. So obviously I will not be going live at the courtroom. I'll be in the courtroom, and they expect it to be about 3 hours. So when I get back to the office, I'll go live. It'll be around 2 o'clock, and then we'll chat. The email attached with an invoice. I again, that's a great inference. I just don't know, to be honest. I have no idea. I go to Twitter to find out the news. I really don't understand what the guy talked about. Like, he went on and on and on. I have no idea. I wish I knew. I was trying to get information about the Pope this morning. The update on Pope Francis was he slept well. That's what they said. It's not funny. It really isn't. It's also probably not true. What did he say? Let's say it says update on the Pope's health Tuesday morning, a very scant statement. More expected this afternoon. It said the Pope slept well. But I moved my thing. Hold on 1 second. I gotta move this mic. He said the Pope slept well last night. Ooh, it's back.
Court is back in session.
May I proceed back to the podium, Your Honor?
Please.
Would you like to remain seated?
You can
Thank
go
you.
back.
May I continue, Your Honor?
Please.
Thank you. So, Your Honor, to blend and quickly summarize what we've gone through I'm using the table of contents. And the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf, July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to the the transcript. And as I go through, I start on page 53,
Okay.
line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them and we'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important, because my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54, and this is going to be in some points a line by line because the words matter. Line 5, and this is again is Attorney Brennan.
Mhm.
Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side and the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCA experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping. It's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before, but his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and he, on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55, Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you, my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information. So they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds? When he really got it from the defense. There's email correspondence between the defense, but not only the defense and the federal government, but the ARCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next on page 57, line 11, he reads, response, hi, Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I'm going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email. That's really not close to what the email says. It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter. And unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARCA experts. Saturday, June 22nd, Daniel Wolf wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, jury requests, and an insistence, the best I can to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. My, that's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll stop back up at 2.
Okay.
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes.
Oh my God.
The 3.3A, I have to.
I'm not rushing you. I just wanted a time frame.
Oh my God.
Your Honor, I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
You are muted.
All right, well.
Goodbye.
I have no idea why she's allowing it.
Is this audio still on?
So I have to go to the post office. I'm going to just let this run. I have to go to the post office and I'll be back. Okay. So I'll be back after this break. Just kidding. Yeah, I thought it would be an hour max too. I'm going to create a banner. Why isn't it bannering? Oh, there you go. Aw, it's cute. It's pink. So cute. This is nonsense. I'm not rushing you. No, why? Why would you not? It's just the court time, Your Honor. That's it. Judge Bling, are you here? Make a t-shirt. The judge is a pushover. Anyway, so I will be back in an hour. Everybody, I'm back. I just have to do a couple things before court starts back up. So I'm going to mute my mic. Hey everyone. So Erica's in here today. And yesterday she was in for like 20 minutes working. She's like, I said, what are you doing? She's like, nothing. Okay. And she went to Olive Garden because, she's pregnant. So she's like, the air. I do love an Olive Garden, but I like Carrabba's better. Do you?
Carrabba's is 10 times better now.
I know, it's so good. Their bread is...
The seasoning, the olive oil.
Which Shelly says she wouldn't waste her time watching from the beginning. Seriously, Allison, with My Father's Alibi? You don't learn anything. Like, there's nothing to have learned in the last 31 minutes other than ARCA loves Olive Garden. That is more learning than you would have gotten from this hearing. Michael, it's nice of Patty to cover this portion of that trial. I just can't stand any part of it. Like, I have no idea what he said. Someone was like, he gave an invoice, did have a date. I think that was Giovanni. Well, they said the emails didn't have a date. They didn't say about an invoice, so we'll see. I had to go make another cup of instant coffee. Oh my gosh. I don't really have any room in here for a coffee maker, so I bought instant and I'm suffering the consequences. But it's only to just put this protein shake in so I don't eat. You wouldn't want to eat after this anyway. So it's fair. Not much happened. 2 breaks, word salad, and some. I'll get to that later. No. Don't forget, tab 2. He said tab 2. He also gave us some words I'd never heard before, which I had to look up, and I put the definitions in the chat because I didn't know what they meant. Oh, you can't stand any part of this trial. I see. Twitter is so funny. Alessi is the type that if you ask him what time it is and he starts explaining how to build a clock. That is true. The man loves the sound of his own voice. Now, I love the sound of my own voice, but I like my voice. But I don't sit there and talk. So bad. Only 5 million years till Alessi is done. Well, I mean, what's her face? Bev asked that like 2.5 hours into it instead of asking in the beginning. Oh, I'm not rushing you. Does she think she's going to go on appeal for rushing this testimony? Does she honestly think that? When was the last time there was an appeal because the attorney wasn't allowed to talk himself into being kicked off the trial? Rash won't get into trouble either. I don't think so. I really don't. Even when you go back, speaking of that, in the bar, the Florida bar, and you look up the punishments, some of the acts that got them to be punished were like 2 years. It doesn't take that long. It really doesn't. It doesn't take that long to decide if someone molested someone or not, or bilked funds out of someone. It really doesn't. Here's the accounts. Here's the documentation. They bilked funds. They took the escrow. Here's your punishment. I swear to God, YouTube chats could solve all these problems. Oh, that's so awful. That's so awful. I don't know if I'm going to be able to do it. I don't know why this is happening. I got to keep this mouse out of my hand. Yeah, it's nice out right now. It's nice out. I went down to the post office, which if you live here and you don't go to the Adams Street post office, you're making a big mistake. That place is humming. It's in and out. You're like, boom, boom, boom. I had 3 packages to send out. Move it along, move it along. It's fabulous. Absolutely fabulous location. For all the guff that United States Post Office gets right now, it's amazing. $47 degrees here. I don't know what it is, but it's nice out. My truck was warm when I got into it. It's cold in here though. Dude, look at that ceiling. Look at that ceiling with that. You would think if they're going to point to the ceiling, they actually clean the ceiling. What the hell's growing in there? They did an audit up in Georgia, like along 75, Valdosta area. There's like 4 or 5 post offices. Guess how many pieces of mail were delayed and just sitting in the warehouse? Almost 60,000 pieces of mail were delayed and have not gone out. 60,000. It's 73. Yeah, it's nice out right now. Don't you think they should clean that ceiling? Like, this is gag. Like, I know it's an old building and all, but shouldn't you? Wonder what that. I was going to say, I wonder what the top of that ceiling fan looks like. Ooh. It's 2:06, people. Let's go. They're not going to finish this today. I mean, unless he's like, well, I still have motions to do. So what's he going to, that's what he's going to do. He's going to out-talk, just like they did last time. Talk so much that Brennan doesn't get to talk today. That's what they're going to do. Likely. Michael says they can pay to have the ceiling cleaned. All they have to do is dust it. I'm not even asked to have anything repaired. Here we go.
We're back in session. You may be seated.
All right, Mr. Larson, let's go ahead and continue.
Thank you, Your Honor. May it please the court, I first want to thank Your Honor for the generous amount of time you're
No
according
need
to.
to thank me. Go right ahead, sir. And take your time, Mr. Leslie. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response in quotes, "Hi, Alan, substance to our conversation on Wednesday, the U.S. attorneys," and he's quoting according to quote the, and it's good to have it, Your Honor, can be having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email,
Yes.
and because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept, because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," he's quoting purportedly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57. Now back to page 60, excuse me, back to page 58.
Yep.
And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, touring requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay. All right.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario, it was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent. And what
Do you have a time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
And I'm understanding Your Honor would like me to pause until you get
Ju-
that.
If we can, because I'm looking at a
Absolutely.
calendar. If you don't, I thought you may have had it. We can move on.
I think it's approximately 6:30 in the evening. It was received by the Counsel.
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Mr. Paul.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So Your Honor, appropriately and understandably, says, what's the date of that? Here's the answer, Your Honor, got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure
I
you.
have it.
Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah. So
Subject-
that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was going to get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not date. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
All right,
And
so
I appreciate the question.
What is
So
the date of the, so you're saying what I refer to as the script was sent on the 23rd?
that is correct, Your Honor.
What was the other one?
The
When
other
that
one was
sent?
sent the day before on June 22nd.
Okay.
I'm just going to give the name that the email has. I think it's wolf_quals document. Okay? So there's 2 emails. One's just the quals. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says.
Sure.
The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I
I'm gonna
just
actually
went.
hold that thought. I just have one other thought. about
Yes,
this.
please.
So we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
And you are
correct.
saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witness's testimony?
The answer is no, Your Honor.
All right.
The
That, I
answer
just
is
wanted
no.
to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate,
Okay.
and I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less than blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago, 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down to the roadway, et cetera, but that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5. It would have been nice to have, I agree, it would have been, and you did, twice. Next, reading on the same page 16, he's quoted. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree, and you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice. In the voir dire and in the direct. In the direct, it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say? We're not. And honorably, Mr. Jackson, nope, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry. There's another point no. Let's go if we could. I don't want to take the lesser significant ones. I want to focus because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2, and then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases. I've been around the federal court a bit. I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made, sometimes parties pick sides, it creates blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than an illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion, it's a statement of fact. Statement about federal investigations that were these are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpreted it as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line, page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and, frankly, of the moment in this trial. And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this, and the court saying the break is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about. facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit. None of
In this case?
No,
Or
I'm
you're saying
talking-
generally, you've had this issue in other cases, or do you mean?
other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break. So we didn't get an opportunity to stand up and say, you know, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds onto the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key. So you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds, and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court. I might have asked for a sidebar and come up and said, Your Honor, my bad. You know, this is that. But that didn't happen. So what did happen? The Commonwealth says, I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of the sentences, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said, the federal government it was the defense. February 13th, they sent us the emails in the direct examination outline. I think I said that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14, what was not corrected? It wasn't corrected that the invoice came from the defense. Just the emails.
I thought it meant everything, but.
I don't understand how that conclusion can be drawn, Your Honor. You didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
Because I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, and you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do. But if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this, being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again, because I was curious about the change in position on February 6th, that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA, because that would naturally preclude the defense from retaining them. So we refrained, and we will not reach out to them. This is really an interesting statement, because you read it, because that would naturally preclude the defense from retaining them, yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So, coming to what happened then. The Commonwealth, having not giving us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that, because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and is inaccurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize your honors giving us that week, and we try to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated. I would now like to move rather hopefully efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because Your Honor brought up
Again,
some.
you don't have to tell me what you're going to do, Mr. Leslie.
I'm sorry, I'll just go ahead and do it. My apologies. So now let's just turn to Model Rule 3.3A1. And this applies to every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the note. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a mistake and it happens, but you got to correct them, right? And what they talk about is what do you have to correct? you have to correct a false statement, so it has to be false. It has to be knowingly false of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th, there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yannetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said, or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank
What page you at?
I am starting on page 40.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it, I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Bugalton, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor obviously has read the February 18th transcripts, you can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court, move to exclude the witnesses? Mr. Brennan, yes. The court, what do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court, I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than waiting. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when then we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. So then it continues on, is important. The court, if I don't exclude it with other side seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided, the federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those.
This guy is trying to run out the clock for the day. That is all he's doing. This is ridiculous.
Handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of, here's what we're gonna collect, here's what we're gonna turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the clause, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when. And so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances, and the case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce. She had financial statements, and she made misstatements, in fact, about her financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In sum, Mr. Yannetti's statements on June 10th, all completely accurate, Mr. Jackson's eliciting of the direct testimony at trial, when he asked, have I ever asked you specific, questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18. Obviously, the Commonwealth is in no position to contact, etc. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So if they can produce the discovery, I welcome ARCA. I want to repeat that.
You don't need to.
I'm sorry, okay. So my point is, we produced the discovery. Why is there still an issue with ARCA? These aren't my words. So I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage, that ARCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, doesn't correct it, the Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped, and I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the U.S. Supreme
Counsel pro hoc vice, or was that?
I'm gonna get to that. The answer is the counsel. I want to be sure my answer. Yes, and I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it. It says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted and it wasn't a revocation of pro hoc vice. There's a difference.
There is a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. Well, I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th? There were some misstatements, and they weren't cured. I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say this as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we made mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it. My presentation notwithstanding, if there's still concerns with the court, we will take them on as best we can and certainly candidly. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All rise.
Potty break. 4 hours and 45 minutes. 2 breaks, a lunch, and he's still an idiot. Like, he could have said all of that in the last 10 minutes and just been 10 minutes. There will not be a decision today. No. There should be a decision, but I don't think. I can't believe she let him go that long. I don't understand. I don't understand Massachusetts. I don't understand anything about the Commonwealth. I don't. Anybody got a clue? Like anyone live in Massachusetts? No, I mean, I don't know. And the free Karen Reader YouTuber people are still like, he was amazing. He was just, he was amazing. This is a class. This is a YouTube class. It's a YouTube class in how to turn off your TV. I mean, no, I don't think so. I don't think so now. Because he literally went on to her being appealed to if Jackson and Yannetti are removed. Yep. I don't think so. I don't think it's going to be a scolding anymore. Mm-mm. Alessi's saying that ARCA's credibility has been injured. He's blaming, saying the media feels like the defense's credibility is injured. What? Like that's Beverly's fault? Wait a second. No, not a hung jury. If Alan Jackson's removed, they can appeal that. That's what he was talking about. They can appeal it, and they talked about misstatements from, I don't know. It was like the misstatements from the defendant or from the attorney, and the attorney was going through. Who gives a shit if attorney's going through a divorce? Sorry, they moved the camera over a little bit, but I can still see the dust on the ceiling. What's it? That divorce they were talking about, it almost sounded like Wendy Adelson, a misstatement in the financials. How can they appeal a hung jury? They did appeal it. They appealed it on that note. They appealed the hung jury all the way to the Massachusetts Supreme Court and lost. But of course, free Karen readers were like, they're criminals. There's fraud. So on this note, there was I had to bookmark it. So this says, defendant's motion to compel video surveillance motion is denied. This was yesterday. Motion for admission of pro hack vice of Mark Betterow. Motion under advisement, meaning they want to bring in that YouTube attorney, another one. Motion to compel discovery, allowed in part and denied in part. The Commonwealth has agreed in the court orders production of the investigative materials sought into the possession, custody, or control of the team. Commonwealth has an ongoing obligation to provide items. There's no requirement under Rule 14, Commonwealth create items that do not exist. Defense requests 2, 3, and 4. The court does not have enough information to determine, denied without prejudice, so they're allowed to come back to that. There was a protective order. Counselor free to file supplemental memoranda or provide the court with the redacted version that both parties have in their possession. Defense request number 5. The requested discovery is outside of the scope of 14. Denied. 6 and 7 allowed by agreement. 8 and 9 denied. It's overbroad. Commonwealth must provide discovery consistent with their obligations under the 14. Definition of work product does not include any items or information the prosecutor is obligated to disclose as items or information favorable to the defense. The court is satisfied that the written response of the Commonwealth indicates the Commonwealth's understanding. Defense 10, allowed by agreement. That was yesterday. So. Back to the dusty ceiling. The town loves to waste its taxpayers' money. It's a Commonwealth. You can't breathe deeply in a Commonwealth state and not get taxed. So that's why money just keeps pouring in. They should honestly doge Canton and the state of Massachusetts. This is layers upon layers upon layers of BS. And I have a feeling with Donna Adelson, that's what Josh Zellman, Donna's new attorney, is going to start doing. He's just going to have motion after motion after motion. And when this all blew up, there were other hearings she canceled with attorneys and clients waiting. Huge waste for a temper tantrum. Yeah, nobody counts but Karen Reid. She walks in the court. I was watching on Twitter. She's got this massive gaggle of humans that aren't working, but really neither are we. So I can't say anything about that. But then, like, the O'Keefes show up and the hate and vileness, it's just unbelievable. Like, that's why Richard Allen, they were moved way out so that the families of both sides could get in there. Bev doesn't have a backbone. They have to park out way yonder, but they don't have to move the public way yonder. I can prove he's a guest of the Commonwealth of Massachusetts. It's not that high of a standard. Just isn't. Lying to the judge is enough of a standard. A Sixth Amendment right is not absolute. And that's federal. It's not like it's state to state. Oh, yeah, he's done, but she probably had to go take a piss. And thank you, Patricia. That's what I said. It's exactly what I said. Lying to the court, when Julie Grant and all these, and Court TV and other people say, you know, he probably lied, you might want to just take it. Nine out of 10 YouTube lawyers are saying he lied. And so YouTube wins. I believe Jackson lied to the judge. That's the issue. Lied to the judge in the sidebar. He just read the sidebar. gotta tell the truth, people. Gotta tell the truth. It's what I believe, but I'm not in charge, so now they're I can't think of it. We'll see. I don't think this is going to end today. I don't. I mean, Hank's been sitting around all day. If anyone says, like, if I get arrested for anything ever again, I delete my emails, just so you know. Like, I don't keep every email or text message. I don't keep every email either that I get, FYI. Like I go through and delete. I cannot keep everything. Bev is heavy prosecution. Oh my God, she is not. She just let him go for 4 hours. Oh my God. You haven't been in a courtroom where, no. Mm-mm. They can't carve shit, Knight. Sorry. They can't carve shit. No. They're going to ask for a recusal of Bev, but you can't lie. You're not allowed to lie. And they've done their own credibility a problem. No, because I'm in here. Seagate's watching it. I am not. I have... If it's anything like that Benjamin Elliott case, I don't want to know. That kid got 15 years for murdering his sister. Oh my God, they're back.
So before I get from the call, Mr. Leslie, I am going to take you up on the offer to ask any questions, and you may have questions for both sides next week. But actually, what I want to do is you said I could ask questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti.
Yes, ma'am.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Leslie? And what I'm particularly concerned about is what you knew or what you didn't know.
No, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript.
No,
I did as well
no,
after I
no.
looked at the
I
transcript.
did long before I looked at that.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed it transcript was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small.
Invoices, payment.
No, nothing. I was, because the context of what Mr. Brennan was talking about being frustrated about were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is the.
Nope, hold on. Ms. Little, it was just thrown on you that that you're responsible for all discovery, but the same question, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay, so I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct of this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARCA was not wholly independent. Information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol, another attorny passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and provide information when the avalanche has started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations at the sidewalk. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know, voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. all of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Lisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Lisi.
It wasn't a request, Your Honor.
You suggested that I called.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. It doesn't help the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not correctly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information, which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it to the representations that have been made prior to trial by the defense that has import. Before, and I'm not going to belabor this and go through your comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vice. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vice attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully to Attorney Inetti, he's a fine attorney, an excellent attorney who I admire, but there's a responsibility so that there are not a number of pro hoc vice lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through 2 requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask the counsel if there were any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please.
Yes.
All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've done.
May I have a moment to speak to counsel?
Sure.
Thank you, Ron.
I'll need to call the United States Attorney's Office and get an answer.
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24th saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like it would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the board here, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, the day 26 of trial.
What date?
Day 26
No,
of
I know
trial.
that, but what date?
June 5th, 2024, discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the content of the report. And those are definitely questions I'm going to ask. So I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's Dave, I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number to the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important to the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024, voir dire hearing. The court asks, well, I thought that you would help.
I've got the transcript. What page you want? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up. Your Honor. Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCA are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions, voir dire, and at trial, about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024. It's addressed to.
Hold on 1 second, please. Okay.
It's addressed to Attorney Jackson, And the position that the defense takes, Attorney Lisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. ARCA experts knew, Dr. Wolf knew, Dr. Rentschler apparently knew, the federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd.
I'm sorry, 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing where the representations were made, there was a June 9, 2024 phone call. Another participated in a telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or was this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony. It is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send. Within 1 month of the defense, they get paid that Commonwealth and the court never knows about. Talking about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness. We have no writing, no email, no correspondence, nothing to support or put in context the conversation, nothing. No. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story, a fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality, the representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6, that's the motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I suggest more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question is going to be, why? Why did they improve? Why did they?
Particular page you'd like to read without citing?
If you look at the first page.
Yes.
Yeah,
You don't have to read any of it, you just tell me what paragraph.
Yeah, I think it's just the first paragraph that lays out their findings.
Thank you very much.
And actually, particularly note number 4, and both publicly, tentatively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we'd be oblivious if we stood here and said that the relationship between the defense and the experts, there was no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline, it's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations or communications the defense had with the ARCA experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right, thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they have been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to provide testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me,
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about what he said that was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was, what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I
Yep.
didn't go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
And let me be clear, I want to make everything. He didn't testify.
It's been a long day.
I understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right, so what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this 3rd person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses, because we weren't talking about the 3rd. The 3rd was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you were calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Unetti, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped on
page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true, because I
read that earlier.
Right, but Mr. Brennan just mischaracterized it again, because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Cannone was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard, and got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no, I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back, I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.38. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3A. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor, which said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it. And I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant, their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said it'd be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brennan?
Very briefly. My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed
on
Late, right? The
February
or
6th.
Saturday or something.
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Manetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not,
Ms.
right?
Little has
It's
only done the
maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Manetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Daniel Wolf, PhD, and Andrew Rentler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Lisi no longer likes the word retain, but that retain word has import. There's a reason he said it. Their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court
What
at
time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
What line, please?
You are muted.
I just can't stand her. So it has nothing to do with guilt, innocence. I just can't stand her. I literally can't. I can't stand how anyone behaves like that in a courtroom. So it's not funny. It's not funny. I don't like it. I think she's absurd. The smiling, it's no different than I don't understand it. I don't know how you can sit there and smile like you are. I don't. So why are they going to federal court? Anybody know? I didn't ask about the correct ruling. Do you want to assume? Let's do that. Let's assume. I love it. I love when there's presumption. Makes my day. What's that got to do with Karen Reed's freaking face? Or her giggling or smiling or cooing? Or what's that got to do with it? There's absolutely no reason to let a lessee speak for 5 hours. There's just none. In any other courtroom, well, in a real place, that would not have been permitted. She just let him go on and ramble. You have a book, you read the outline, here's the judge. You're not persuading anybody. She already knew what she's going to say. She just doesn't want to do it in open court. She hasn't made, I don't think she's made any rulings in open court. Has she? I don't think she has. Who won't answer who? They didn't have to testify. She said in the beginning, if the defense doesn't want to speak, they don't have to. 5.5 hours later, good night. Hi, Lolly. It's all a smirk. It's just so obnoxious. Oh, yeah, because they're all like oohing and awing and praising and applauding when she walks in. And the O'Keefe family is literally mocked and jeered and screamed at. I can't either. 5.5 hours. Yep. Anyway, they're working on my roof now. So I will be on tomorrow around 2:30, I guess. I'm going to the hearing for I'm going to have to tape another cord. Around 2:30. So Donna's hearing is scheduled for 3 hours because Judge Everett is not a wimp, and that should be that. 3 hours, not 10, not 12, not we're ending at 4, 3 hours. Finish it. Get it done. Speak faster, up your pace, move on. How can other courtrooms accomplish this, but this chick can't? Have a nice night, all. Thanks for spending your time. It was a pleasure. It really was a pleasure, even though I'm making fun of it. It really was a pleasure. Thank you all. I'll see you tomorrow at 2:30 or as close as possible. Have a great evening. Pray for the O'Keefes. Take care, everyone. Thanks. Bye-bye.